Today I will be discussing the Patient Protection and Affordable Care Act on behalf of Group 3. The state of our healthcare system was not in good shape. Although programs like Medicaid and Medicare existed to help low-income and elderly individuals, it still left many others to fend for themselves against the rising cost of healthcare. A potential solution for these problems became law on March 23rd of 2010 in the form of a very large bill known as the Patient Protection and Affordable Care Act, or PPACA for short. The purpose of the PPACA is to provide coverage to approximately 30 million people in the U.S. who would have no health insurance, and ultimately it was to change the structure of how healthcare is delivered within the United States. The PPACA provided a much-needed transformation of the U.S. healthcare system. It was the largest change to our healthcare system since the establishment of Medicare and Medicaid in 1965. The new law is full of provisions. Some of the key provisions include the creation of healthcare exchanges and the expansion of Medicaid. They were created to fill in the gaps that previously resulted in millions of Americans being uninsured. Essential health benefit packages have been established to ensure coverage for preventative services and will be available to patients without having to pay high out-of-pocket costs. Protections for those with pre-existing conditions, additional funding for the Children's Health Insurance Plan known as CHIP, and also non-minor dependents now have the ability to remain on their parents' insurance until age 26. For low-income individuals whose incomes fall below a specific percentage of the federal poverty line, depending on the state, have the option to get coverage through Medicaid if their state decides to expand the program. In the case of the National Federation of Independent Businesses versus Sebelius, 26 states brought to suit the individual mandate and Medicaid expansion. The law originally stated that any state that did not comply with the Medicaid expansion requirement would lose all of its federal funding for the program. The Supreme Court made the decision to uphold the individual mandate as a tax penalty, but made Medicaid expansion optional for states. Unfortunately, this leaves millions of uninsured people who could otherwise be insured if their state made the decision to expand the Medicaid program. Healthcare exchanges were designed to reduce costs and improve access to coverage for those who buy insurance individually or for small groups. The healthcare exchange gives individuals and small businesses access to insurance options. An individual can compare benefits for different tiers of coverage and premiums. Of the many requirements listed within the Affordable Care Act, the individual mandate requires most people to obtain insurance coverage, whether it's through the exchanges or some other platform. If they choose not to, they may be subjected to a penalty that comes in the form of a tax. As with many programs, there's always someone who qualifies for an exemption. In fact, 90% of those who will remain uninsured even after the implementation of this law will be exempt from the penalties associated with not obtaining coverage. Some of these exemptions include not being able to afford coverage for less than 8% of their income, those who are not required to file a tax return because their income is too low, and people who are incarcerated or not lawfully present in the United States. In addition to these exemptions, financial hardship could cause a person to be exempt from paying penalties. Those who are going through foreclosure or bankruptcy, the homeless, and many others fall into this category. A substantial portion of the PPACA stands to make sure that the financial security of Americans is not damaged by healthcare costs. The establishment of accountable care organizations was created to aid costs for Medicare patients and is a volunteer program in which high-quality care is provided to the patients by doctors and all healthcare providers who work together in hospital settings. ACOs will implement goals of the mandated Medicare Shared Savings Program that was established by the PPACA. The anti-kickback statute and antitrust law are the main legal issues regarding ACOs because of the way they're set up. ACOs have the possibility of stifling market competition or promoting providers for payment, which is strictly forbidden under these laws. The medical loss ratio was made to ensure that patient premium dollars are spent on medical care and not administrative costs. This provision states that if the MLR of an individual or small group market falls below a specific point, the insurer must rebate to its enrollees the difference between the reported ratio and the target percentage. In addition to patient protection, the new law also makes efforts to protect the financial losses for insurance companies and medical facilities. Risk adjustment, reinsurance, and risk corridors, which are referred to as the 3 Rs, are mainly responsible for protecting insurance companies against financial losses they might have to take on when insuring patients that are considered to be high risk. It ensures that health plans compensate appropriately for risks as well as regulate payments to health insurance plans. Reinsurance is responsible for reducing losses. When insurers experience unexpected high costs, they are reimbursed on a sliding scale. The losses and gains are scored and limited by risk corridors for qualified plans. Of course, it's no big secret that there has been plenty of opposition to the PPACA. There have been numerous lawsuits, some of which have made it all the way to the Supreme Court to be settled. I have previously mentioned the case of the National Federation of Independent Businesses versus Sibelius, which has implications that could cause a ripple effect throughout the entire healthcare system. For those who live in states where state exchanges have not been established, they still have the ability to sign up via federal exchanges. The main issues here relate to the case of Halbig versus Burwell, which ruled even though Americans who sign up for federal exchanges may qualify for subsidies from a financial standpoint, the IRS is not authorized to pay out these subsidies because the PPACA only mentions that subsidies will be paid to those who register via state exchanges. Without the subsidies, millions of people will be dropped back into the category of uninsured all over again. Another remaining issue is in regard to a provision within the PPACA that required employers to offer plans for their employees that included coverage of contraception at no cost to the employee. Hobby Lobby, a closely held for-profit organization, rejected the coverage of certain forms of contraception on the grounds of religious freedoms. The court ruled in the favor of Hobby Lobby, and it may take some time before we see the end of this conflict. Section 1981 of the Civil Rights Law was enacted in 1866. Its main focus was to make sure that all contracts, including employment contracts, were upheld regardless of the races of those involved. This was a great step in the right direction for those who had previously been without equal protection of the law. Section 1983 of the Civil Rights Act prohibits the deprivation of any rights or privileges which are secured by the Constitution and other existing laws. This section is similar to Section 1985, which states that all citizens, regardless of social status, culture, ordinance, or custom of the United States, will be included and protected from conspirators. Crimes of conspirators include obstructing justice, intimidating a witness or a juror, and depriving a person of their rights and privileges, which also includes damages to property. Title VI of the Civil Rights Act of 1964 prohibits programs or services that receive federal financial assistance from discriminating against individuals based on race, color, or national origin. Recipients of federal financial assistance such as hospitals, police departments, unemployment centers, and social service agencies cannot deny services, aid, or other benefits. Title VII of the Civil Rights Act prohibits discrimination within employment settings on the basis of race, color, religion, sex, and national origin. In conclusion, the Patient Protection and Affordable Care Act currently stands as a complex form of the United States healthcare system. Even with all the positive changes the PPACA brought in attempts to resolve the issues with access, affordability, and quality in healthcare, there still remains a large number of people who are uninsured, unprotected, and are still struggling to provide health coverage for their families. Implementing new change is never an easy task, and it may be a while before the PPACA is operating to its fullest potential.